of the Murphy Institute on Catholic Thought, Law, and Public Policy. And together with the Initiative on Restorative Justice and Healing, we are sponsoring today's launch of Professor Berg's new book, Religious Liberty in a Polarized Age. Professor Andrew Koppelman of Northwestern and Asma Uddin of Catholic University will offer commentary as well, and Professor Berg will introduce each of them in a moment. Today's program comes at the very heart of the mission of the Murphy Institute and the Restorative Justice Initiative. We both greatly value religious liberty, and so this would make it a perfect program to be sponsored on that alone. But in addition, both the Murphy Institute and the Restorative Justice Initiative have a heart for encouraging civil discourse and reducing harmful conflict in our society. And Professor Berg's book directly takes on the polarized nature in our country, seeking ways to bring about greater healing and urge us to listen to and engage with each other. So a couple of notes before I turn over to Professor Berg. First, as a special offer for this event, Professor Berg's book is available for sale at 50% off just outside the room. Second, 1 hour of continuing legal education has been approved for this program. And third, the format today is that Professor Berg will offer some opening remarks. Each of his guests will offer comments. There will be an exchange among the three of them, and then we will conclude by taking time for questions. Professor Thomas Berg is the James L. Oberstar Professor of Law and Public Policy here at the University of St. Thomas School of Law. He holds a JD from the University of Chicago and a master's degree in religion from that same institution, and a master's degree from Oxford University, where he was a Rhodes Scholar. He is one of the nation's most prominent, most prolific, and most active scholars and advocates on religious liberty. He is the co-author of the leading case, Religion and the Constitution, the leading case book, Religion and the Constitution, along with dozens of book chapters and articles. He has also drafted nearly 60 briefs on religious liberty to the Supreme Court and to other courts. Professor Berg.
So thank you, Greg, very much. Thank you to the Murphy Institute, Greg Sisk, Father Martin Schlag, co-directors of the Murphy Institute, and especially to Michelle Rash, who, is Michelle in here? She's outside making things work. She's done so much of the planning for this, so thank you very much, Michelle. Thank you to the Institute for Restorative Justice and Healing, Father Dan Griffith, who is also the pastor at the Basilica over here, and Julie Craven for their co-sponsorship. And thank you to all of you for coming. And then also, obviously, thanks to Andy Koppelman and Asma Uddin, who I'm very honored to have here talking about the book. I'm going to just briefly introduce Andy and Asma. Their bios are on the event site, and to do the bios would be really long. So I'm going to just say a couple of things that I think are quite relevant about each of them. Andrew Koppelman, who is teaches at Northwestern University School of Law, is a prolific scholar of constitutional law and legal philosophy. And you can look for his books and his articles and his sort of public interventions in the Hill website. He writes regularly there. But among other things, I want to draw attention to, Andy is a foundational proponent of the argument that denials of same-sex marriage or other forms of discrimination, again, based on same-sex relationships, are sex discrimination under the Constitution and under statutes. He made that argument quite a number of years ago and has continued to make it, and it's been very influential. He's also the author of a book called Gay Rights versus Religious Liberty, Question the Unnecessary Conflict, where he doesn't have a question. He doesn't say, question whether it's an unnecessary conflict. He says it is an unnecessary conflict. And it is a book about that conflict that's at the heart of my book as well, and how to protect both sides. And I was influenced by that book and engaged with it in mine. It's really important. Asma Uddin from Catholic University is an influential religious liberty advocate and scholar. Her first book, called When Islam is Not a Religion, documented the rising tide of denials of religious freedom and equality to Muslims in the first decade or so of the 2000s. Her second book, most recent, called The Politics of Vulnerability, analyzes the dynamics of religious freedom disputes involving both Muslims and conservative Christians, and suggests, among other things, how those two might find some commonality in defending religious freedom. Growing out of that book, she's doing important current work on how to defend religious freedom in ways that cut across ideological lines. And her work, like Andy Koppelman's, has been a real guidepost for me. So that's why I'm so happy that both of them are here. So here's my perspective in the book. Religious liberty is meant to protect people from having to suffer at the hands of the government for living according to their deep beliefs about the divine, about the ultimate meaning and purpose of life, and so forth. And since both religious practices and government actions, government regulation, are perennial features of society, that goal, that project of religious liberty, is perennial as well. And as I looked at our current polarized society, and the first chapter of this book is a deeply depressing chapter describing where polarization comes from, how far it goes, and so on. But I was struck by ways in which we are repeating, in a soft version, thankfully a soft version, the habits and cycles of conflict that required the commitment to religious liberty in the first place. In Reformation era Europe, civil rulers attacked Catholics, or attacked Protestants, or attacked one group of Protestants as against another. And those who were attacked not only suffered, but became fearful and angry. And if they could get government power, then they would in turn use it to employ government to attack the other side, or attack the other side before it could attack them, right? Anticipate it. As James Madison described it in one of the great documents of religious freedom called the Memorial and Remonstrance Against Religious Assessments, he described this as torrents of blood spilt in the old world by the vain attempt of the secular arm to suppress differences in religious opinion. When the government gets involved, it involves this cycle of violence. The ultimate solution to that cycle of violence, at least a partial solution, was religious liberty. Madison called it the true remedy that has always been found to reduce the severity of the disease. The true remedy was full and complete and equal religious liberty. Religious freedom for different groups, which Europe finally inched its way towards and then was brought over to America, and we have inched our way towards, but we've made commitments to it, doesn't eradicate the existence of conflict between deeply held views. Madison said, you try to eliminate that conflict, that cure is far worse than the disease of the conflict itself. It never works. Religious freedom doesn't eliminate the conflict, but it sufficiently eradicates its malignant influence on the health and prosperity of the state. And those words, just as I thought about them in our current situation, had more and more resonance in my mind for today. We have that cycle today. For far too many conservative Christians in the last 20 years, treating Islam as inherently a threat to American culture or security has led them to support discriminatory restrictions on Muslims, to block the construction of mosques, to place broad bans on so-called Sharia law, which could extend to just even the, two business people making an agreement together to kind of have their relationships governed by Islamic ethics in a commercial sense. Very broad-ranging bans on the use of so-called Sharia law. The ban on travel from Muslim-dominated nations by President Trump. In turn, many progressives, viewing conservative religious believers as a threat to LGBTQ and other rights, fear and resent those religious conservatives. They refer to them as bigots, and they seek to forestall the harms that they will cause by applying anti-discrimination laws with few or no protections for religious groups. Conservative religious believers are fearful and angry about that. This dynamic played a significant role in the people who called the 2016 election the Flight 93 election. Remember that phrase? It was, you've got to stop. The plane of the nation is about to fly in the building. We have to stop it from going in that direction. Religious liberty was a major part of those fears. The Solicitor General of the United States, speaking before the U.S. Supreme Court in the same-sex marriage case in 2015, Obergefell, was asked whether recognition of same-sex marriage would mean that the tax exemptions federal tax exemptions would be under threat for all groups that had opposition or that engaged in discrimination based on their view of marriage. By analogy to the withdrawal of tax exemptions from racially discriminatory groups in the 1980s. And the Solicitor General said, yes, Your Honor, that's going to be an issue. That's coming. That statement got a lot of play during the 2016 election among religious conservatives. Under these threats, conservatives have made real religious freedom claims, and I believe that many of them are real and strong religious freedom claims. There's also, however, they've also doubled down on restrictions, in some cases restrictions on Muslims, and especially on LGBTQ people. And then, so progressives then point to that as further evidence of the need to stop conservative intolerance, right? So then we need to stop conservative intolerance, and then that means, of course, the conservatives will have to react to those efforts, and there's the cycle of retaliation. Each move by one side gives the other a reason to double down. Today, religious liberty can reduce the suffering and coercion, and therefore the fear and retaliation, and I argue the cycle of retaliation. So protection of religious liberty can again be a means of at least reducing polarization or preventing it from getting worse. Protection of religious liberty can play that historic role, I argue, if the protection, number one, is strong enough to actually give protection to different groups. Two, it extends to all religious views. It's got to be equal. It can't be protection for me and not for thee, which happens too often. And third, it has to take account of other important interests, like, for example, LGBTQ rights, which do not fall under the rubric of religious freedom, but are important competing rights. So my first point there and the third point combined, which is religious liberty should be strong, and it also has to have boundaries to take account of other rights, means, of course, that to a significant extent, the devil is in the details here. How do you have a strong but also boundaries? But I try to argue throughout the book in analyzing various issues that careful analysis can optimize that balance. So I make arguments in the book for why protection of religious freedom is important historically and in our times. Religious freedom can again reduce fear and alienation and promote allegiance to the government. I also make an extended analogy between the rights of same-sex couples and those of religious objectors, of the Catholic groups that object, Catholic foster care agencies, the wedding vendors, and so on. And this analogy argues for giving significant protection to both sides. If there's one thing I'd like people to remember from the book, it's that asserted analogy, and to grapple with that analogy. So what is it? First, both same-sex couples and religious objectors seek to protect a pervasive feature of their identity: relationship with the partner, relationship with God, following the commands of a loving God. Second, that identity is lived out in conduct. It's not just an identity, it's lived out in action. Gay and lesbian people were told wrongly that they could have their orientation, but that didn't mean a right to live it out in marriage. Religious objectors are also told wrongly that they can have their beliefs, but that doesn't mean you can live or act according to them. Third, that conduct, so it's the identity and conduct together, is not just private, but it's public in a sense, in important senses. In civil society, we're gay and lesbian people, not just in the closet, but in civil marriage, in public. Religious people, not just in congregations or in the homes, but in their schools, in foster care services, in the workplace. And it's complicated questions there, but I really hope that trying to see those parallels does not mean that the two rights are not deeply in conflict. Of course, there are real conflicts, but if we could see the ways in which each operates for the person in their lives with this kind of importance, then maybe we could increase some of the sympathy that we have across lines. Sympathy not for the other's point of view, for the correctness of it, but for the predicament that people on the other side are put in when the government penalizes them. Then in the third section, principles for the scope of religious freedom in key areas. As I said, the devil is in the details. But I claim that we can optimize or maximize the combination of protections. Let me just say two quick things there. An obvious way to do this is to enact LGBTQ non-discrimination laws in Congress and in the many states where those don't exist, with significant religious exemptions, again, based on the analogy between the two sides. And the second way that we can balance is by drawing appropriate lines on the scope of religious exemptions. And in the LGBTQ context, I make an argument that this calls for quite broad protection for religious organizations, nonprofit religious organizations that hold themselves out as religious, and protection for the vendor in the commercial sphere, yes, and those are controversial, the cake designer, the website designer, but those are much narrower. And I think and I argue that we can identify a class of objectors who ought to be protected, and the reasons for that. Is this possible? Is it possible to enact these things? It's hard, but Congress did it in December in something called the Respect for Marriage Act that both gave same-sex couples a statutory recognition of marriage rights in case the Supreme Court overturns it's a constitutional decision, and at the same time provided protections for religious organizations. So Congress actually did it last December, and Utah did it a few years ago. Utah, a deep red state, passed a statewide gay rights statute. It only passed because there were significant religious exemptions in it, but deep red Utah has statewide LGBTQ rights protections. Now, I won't say that Utah is perfect, but let me finish by just reading something from Jonathan Roch, who wrote one of the strongest early books, in my view, for the case for gay marriage. And he writes about what happened in Utah. And I quote this at the end of the book. He writes about the group called Equality Utah, that is the leading gay rights group in Utah. He writes, when I asked Equality Utah's executive director, Troy Williams, to name the downsides of this statute, SB 296, from the point of view of Utah's LGBTQ community, he couldn't think of a single one. The culture has changed here in Utah, he said. In every possible way, Utah is now a safer and more welcoming state for the LGBTQ community. When I asked if the same change would have happened without SB 296, the statute with the religious exemptions that put it through, he replied with a firm no. It changed the dynamic forever in the legislature. I've watched so many legislators open up their hearts in this process. And then Roch writes, and that openness was a two-way street. So Jonathan Roch continues, an agreement of this sort in other states could show America what SB 296 showed Utah. Even when we disagree on our core beliefs about faith and identity and justice, we can still share the country. We can still reverse spirals of polarization. So with that, let's have some comments from Andy Koppelman first, and then Asma Udin.
Homburg's book makes a powerful case for deploying a broad principle of religious freedom as a strategy both to make American law fairer and to reduce the polarization of politics. The book is a marvelously clear, concise overview of the legal, ethical, and political issues raised by today's conflicts over law and religion. And his conclusions broadly overlap with those that I've developed in my own work, like my book, which he just mentioned, Gay Rights versus Religious Liberty, The Unnecessary Conflict. Here, I am going to focus on an impasse that neither of us resolves and note a possible way out of it. Both of us address the question whether religious people who conscientiously object to facilitating same-sex weddings and who therefore decline to provide cakes, photography, or other services should be exempted from anti-discrimination laws. We both think they should be accommodated when this can be done without defeating the purposes of the laws for which exemption is sought. With public accommodations laws, we both say the pertinent state interests include ensuring that people have full access to goods and services and that they not face regular refusals of service that inflict immediate humiliation and ongoing apprehension. In order to avoid that latter harm, I argued that businesses should be permitted to refuse to facilitate same-sex weddings if they publicly make their objections clear, so that gay people don't come and get turned away. He responds accurately that so far no legislature has shown interest, and LGBTQ rights groups probably think that the notices themselves would stigmatize. Instead, he has a different proposal, that courts should provide small businesses that provide personal services directly to facilitate a wedding or marriage where other providers are regularly available. Now, I'm going to begin my response by repeating some points I made in my book. Lawyers are trained to think about conflict resolution by devising abstract principles that should cover all future cases and which incidentally entail that my client wins. But this is not the only way to think about conflict. Sometimes the right thing to do is not to follow a principle at all, but to accurately discern the interests at stake and cobble together an approach that gives some weight to each of those interests. Ethics isn't only about principles. There's a tradition in moral philosophy going back to Aristotle that holds that a good person doesn't necessarily rely on any abstract ideal, but rather makes sound judgments about the right thing to do in particular situations. Sometimes principles are overbroad generalizations from experience and distract us from the moral imperatives of the situation at hand. The nature of the accommodation that's needed in this situation is both specific and abstract. It may sound paradoxical, but the particular judgment at issue needs to take the form of a rule. The standard formulation of the Federal and State Religious Freedom Restoration Acts is, you grant an exemption unless denial is necessary to a compelling government interest. That is fatally indeterminate as a way of resolving cultural conflict. I repeat what I said in my book. It's hard to compromise when we don't know what we're agreeing to. lawyers distinguish between rules and standards. A rule is clear and easy to apply. There's no doubt about how you're expected to respond to a red traffic light. Standards, on the other hand, the injunction to drive with a reasonable degree of care under the conditions. That involves more discretion and unpredictability in application. Rules are cruder, but one can be much more confident about how they're going to be applied. And this is the deepest problem with any balancing judicial resolution necessary to compelling government interests. They all involve the application of contestable standards. And the principles with which judges work don't yield bright lines. They yield general considerations that have to be worked out on a case-by-case basis. So I concluded this is a job for legislatures and not for courts. Being here at St. Thomas, I have to invoke Thomas Aquinas. Aquinas thought that there was an aspect of law which he called determinatio. A rule can be derived from the natural law in two ways. First, as a conclusion from premises, where natural law will straightway entail an obligation of the state not to harm innocent people. Secondly, by way of determination of certain generalities. And that determination is necessarily somewhat arbitrary. We all need to drive our cars on the same side of the street. Natural law doesn't tell you which side, but it better be the same side. But it's not unconstrained. John Finnis says, though explaining Aquinas, though the lawmaker's determinatio is in a sense free, it must also be made with due consideration for the circumstances which bear on the appropriateness of alternative laws. General principles of religious liberty can't yield determinatio. The most familiar judicial attempt to deduce rules from abstract principles is the trimester framework of Roe versus Wade. And very few people were persuaded. When the court overruled Roe, it declared that the court in Roe had concocted an elaborate set of rules with different restrictions for each trimester of pregnancy, but it did not explain how this veritable code could be teased out of anything in the Constitution, the history of abortion laws, prior precedent, or any other cited source. So courts can't enact the notice requirement that I proposed. Tom Berg and other scholars have proposed a safe harbor for businesses of 5 employees or less, which would specify his proposed exemption for small businesses. That's what small businesses are, 5 employees or less. But he understands that decisions applying a general religious freedom standard couldn't set an exact numerical ceiling. That's why legislatures have a comparative advantage here. And the problem is that legislatures have no interest. Red states won't protect gay people from discrimination. Blue states have become increasingly hostile to religious accommodation. He optimistically writes, the Supreme Court has stepped into the void and protected both sides. But the protection that the Supreme Court has offered is crude and overbroad. A recent Court of Appeals decision, with which I'm going to end, shows that, but a footnote in its opinion offers a possible path to a better resolution. The case presented the question of religious exemptions from Title VII of the Civil Rights Act of 1964, a statute which, like all of federal law, is subject to the Religious Freedom Restoration Act. A business claimed a religious right to discriminate on the basis of LGBT status, and the question was handled somewhat clumsily in the district court, although I think the district judge, Reed O'Connor, can plausibly argue that the clumsiness was mandated by Supreme Court precedent. He explained that government hadn't shown a compelling interest in preventing discrimination, relying on the most favored nation theory of religious liberty that is embraced by the Supreme Court. The Supreme Court has said denial of a religious exemption is presumptively unconstitutional if the state treats some comparable secular activities more favorably. And Judge O'Connor observes that for no apparent reason other than administrative convenience, Title VII exempts businesses with fewer than 15 employees. The Supreme Court had held that when there was an exemption like that, it undermines the state's claim that its interest is compelling. And so the same exemption needed to be extended to religious claimants. Now, this is a path to exemptions, but it is way overbroad. The most favored nation theory is so capacious, it's hard to imagine any case in which it won't support exemptions, no matter how destructive they are to legitimate secular interests. And its tendency to construe religious liberty as a right to violate any law that doesn't pursue its purpose with monomaniacal intensity, can't be possibly pushed to the limits of its logic. An earlier, saner court observed that all laws are selective to some extent. So the effect would be to make the religious a sort of aristocracy that's entitled to violate any law with impunity. I elaborate on this in a piece on the increasingly dangerous variants of the most favored nation theory of religious liberty that is now in the Iowa Law Review. Because the court is not composed of anarchists, and because the theory generates colorable claims on behalf of religiously motivated homicide, we allow self-defense, devaluing religious reasons. I argue that the most favored nation theory in practice will be necessarily selective and is likely to benefit claimants the judges like and to constrain laws the judges dislike. Well, on appeal, the Fifth Circuit offered an escape hatch. It's not clear whether the Supreme Court will permit it, but it's worth trying. In the instant case, the Fifth Circuit, Judge Jerry Smith wrote, the EEOC doesn't show a compelling interest because you've got the EEOC's got to show an interest in denying this claimant individually an exemption, and there are lots of other businesses that will provide the same service, the same job, so it doesn't matter. What harm could possibly come from one person discriminating? But this is true of a lot of laws. Once an exemption is granted, the cost of claiming it is low, and so sincerity is almost impossible to determine. And there's a danger of opening the floodgates to so many claims that the underlying law is defeated. The district court entirely ignored this issue, but the Fifth Circuit wrote in a footnote, an example of a less restrictive means of furthering the government's interest could involve the EEOC's propagating guidance that provides a framework for employers to oppose homosexual or transgender behavior on religious grounds to obtain an exemption. The lack of any guidance or method of gaining an exemption gives rise to the inference that the EEOC has no intention in granting an exception regardless of an employer's religious exercise claim. This could be read as offering government a lifeline. If the EEOC will promulgate regulations and say who is entitled to an exemption and who is not, that could provide the determinatio that deductive legal reasoning can't supply. It could say who qualifies for an exemption and, more importantly, who doesn't. Courts can't provide determinatio, but they can have determinatio forcing techniques. Most obviously, statutes are sometimes invalidated for vagueness or overbreadth. And when that happens, the legislature is sent back to the drawing board. I know this is important to you. You want to do this, try again. The footnote can be read as an instance of that techniques. And if legislatures or agencies are required to draw lines, they might incorporate my proposal. They might incorporate Tom Berg's. They got to do something. That does raise the issue whether it's ever permissible to draw the line anywhere. The Fifth Circuit supposes that it is, but if laws can never treat any religious claims worse than any other claims, because any exception shows that the state's interest is not compelling, Justice Alito made that claim in the Little Sisters of the Poor case, then religion does always win, because there are no laws that are applied relentlessly in all cases. The fundamental problem with the law of religious accommodation that the court has crafted in recent years is that while an exemption might trigger heightened scrutiny, the court hasn't made clear how a state can successfully respond to that heightened scrutiny. The scrutiny that's triggered has become so skeptical that it is unclear how a state could possibly meet it. But this situation is unstable because the court can't possibly mean that all religious claimants win. The Fifth Circuit's footnote is essentially an invitation to legislators and administrators to probe this territory by specifying the field of exemption. Legislatures that want to prohibit discrimination and which may have no interest in allowing any exceptions are now on notice that they'd better create some, or they will not like the very broad ones that courts will force on them. In order for this to work, though, the Supreme Court would have to show some interest in clarifying the relationship between the triggering right to heightened scrutiny and the ultimate right to exemption. And that means that sooner or later, it is going to have the new Supreme Court with Judge Barrett on it, which is so friendly to religion. That court would have to rule against some religious claimant on the merits and explain why, and that has never yet happened. Until that happens, until the Supreme Court does this, the conflict between religious liberty and gay rights is only a small part of the trouble we are in. Thank you.
Great, thank you. Can everybody hear me?
Yes.
Okay.
Yes.
So I thank you to Professor Berg for having me join you today. I'm sorry I couldn't be there in person, but I'm actually in Oregon running some interesting research that I will share with you in a bit that is relevant to the topic at hand. So I've been in this religious liberty space for about a decade and a half. And I think for me, I mean, for one, I have found religious liberty to be, to always sort of keep things interesting. Like it's provided lots of interesting puzzles for me to solve throughout the course of a relatively short career in it. It's provided a case study for, I think, some of the most pressing and complicated issues in our culture and politics today. And, you know, if I were to tell the story of religious freedom, at least that's how I've experienced it in the past decade and a half, I think it's just even in that short time has gone through some pretty significant phases. If I were, so like when I first started in this space, I think religious liberty for me was generally an uncontroversial premise. You know, I think when I started like about late 2009, I think the most contentious issue in religious liberty at the time was the question of religious displays in the public and sort of on you know, public ground or like city halls. Like that was the thing that we used to fight about. And you know, it was something that I think that most Americans, at least in my sort of interpretation of it as a junior attorney, was something that people just sort of agreed on. We kind of just, it wasn't that difficult to kind of find common ground. And then sort of a couple years into that began to change. I was an attorney at the Beckett Fund, which was the lead attorney in the Hobby Lobby case. And suddenly I kind of came from the space where things were, you know, source of agreement to a source of deep disagreement. And I was in the center of it all. I was on I was on Al Jazeera. I was on the front page of the New York Times, and, you know, kind of like thrust into it in the most public way possible. And suddenly religious liberty went from something that brought people together to suddenly becoming something that people wrote with scare quotes around them. Kind of like, what is this thing and what does it really mean? And is it really just a pretext for something far more sinister? And so, I mean, I can kind of go through some of that, but I think that Professors Berg and Koppelman have kind of told you about that fight. A lot of it centers on the question of sexual freedom, whether it be in the form of contraception, abortion, or same-sex marriage. But for me, kind of being in that space and sort of also increasingly hearing rhetoric around the importance of religious liberty on the one hand, and then from the other side, this idea, again, of religious liberty as a mere pretext for discrimination, I think what I found striking in the midst of it all was the way that religious liberty, even from those who were the sort of the staunchest defenders of it and the loudest sort of voices on it, tended to be defined in a particularly inconsistent way. And this was the part of it that kind of really began to become clearer and clearer to me. And this period was sort of, and you know, among sort of the issues that I was dealing with in this context was also the sorts of things that became clear during President Trump's 2016 campaign, where religious liberty was seen as sort of the quote unquote most important issue. Was that religious liberty was sort of the central issue of the Republican presidential campaign. There were candidates after candidates who were sort of talking about how they would defend religious freedom better than their competitors. But the other sort of consistent theme in all of this campaigning was how simultaneous to protecting religious liberty, Muslims are going to be banned from the country. Their neighborhoods are going to be surveilled. There was going to be a Muslim registry. There were problems with mosques, right? Like then candidate Trump was on TV talking about how, quote unquote, Islam hates us, or we have to deal with the mosques. And so that inconsistency became pretty hard to ignore. Again, I had seen earlier signs of it in just kind of being in the center of the religious liberty world. But if there was ever kind of a way of just sort of bringing that more acutely to my attention, that was it. And so I decided to turn to that particular part of the problem of religious liberty and polarization today. And as Professor Berg mentioned in my bio, I first tackled that in my first book, which is titled When Islam is Not a Religion, Inside America's Fight for Religious Freedom. And the title came from a claim in an actual case where a local community in Murfreesboro, Tennessee, brought a case against the county for issuing a zoning permit to the Islamic Center of Murfreesboro so that the Muslim community there could move forward and build a mosque to serve their needs. And the argument in that case was literally that the Muslim community should not have access to religious land use protections because Islam is not a religion, and you have to be a religion in order to have religious freedom. And so the book is titled after that, and that is one of many issues that I talk about there. Again, Professor Berg mentioned the consistent movement against Muslim arbitration, similar sorts of challenges against houses of worship that the Murfreesboro community faced has actually been the case across the nation. Of course, there's a travel ban. There's even been, the things that I thought we all agreed on, such as the ability to wear religious garb in the workplace, has also been contentious in some contexts. So that's what the first book was about. And then the second book was really, in writing that, a lot of people ask the question, why is this happening? Where's this opposition coming from? And I think oftentimes we have like the relatively simple answers to that question, right? Especially in the context of Islam, you can say that there's a racial element, right? Lots of scholars out there writing about the racialization of Muslims and how Muslims are seen as uniformly brown or non-white, even though that's very much not the case. There's also the question of Islam and national security, right? So it's an easy target when people are fearful about security. But there was just a sense to me, especially again, being in the middle of these religious liberty fights, seeing the way that religion itself was being politicized and become a partisan tool, that I was like, I think there's something more to it. And what I discuss in the book is I actually turned to social science. Like in the course of kind of thinking about this, I sort of stumbled upon social science scholarship that really was kind of making clear to me that in many cases, Islam is being seen as one and the same as well, I apologize for the background noise here, as sort of being associated with Democrats, especially during the Trump era. Who was speaking out against Muslims and who was defending Muslims? And it became a question of team red versus team blue. And so in the book, I kind of talk about one sort of like the human phenomenon of group identity, of intergroup bias, but then I also talk about this idea of mega identities and the way that our religion, in addition to so many other aspects of ourselves, has become mapped onto our political identity. And that so much of this opposition that has been documented by, for example, white conservative evangelicals against American Muslims is in large part a byproduct of conservative opposition to liberals. And then from there, then the question then becomes, okay, now I've sort of uncovered the why. Now the question is, how do I solve this? And to that end, I look at a couple of social science strategies, such as subordinate goals. This idea that, again, Professor Berg also touched on, that how can people kind of come together when they have a joint sort of interest in religious liberty. I've explored that in my religious liberty, my legal scholarship, which I can get into if we get to the Q&A. And I just, I want to conclude, I'm also cognizant of our time and that we're running out, but I do want to say that in recent months, in this sort of like story of religious freedom, the story of religious freedom, my career, I feel like we're entering another phase of it. And I think the interesting sort of issues that continue to evolve Whereas in my book, I was looking at the question of majority minority. I think there are some interesting new scenarios that are coming up, in which this is sort of turning into a minority versus minority battle. I am currently in Oregon, but I live in Montgomery County, Maryland, where currently there's a lawsuit pending against the school district regarding the LGBTQ curriculum there. And the face of that conflict has, in many cases, been American Muslims. And that has actually sort of raised really interesting questions for me as to like, what do you do in the sort of the new or complicated iteration of the sort of pluralism project when it's two minorities and they're kind of having this conflict? Thank you.
Just a comment about our time. There is no class in this room after 1:30, so it will not run against an artificial time limit. So you're welcome to stay. There'll be a brief exchange among the three, and then there will still be time for question and answer from the audience. Speaking about rights, one of the rights that a moderator has is to ask the first question. I am going to surrender that right because actually I have to leave to go to class myself, so there will be no moderator. Let's hope that in this polarized time, you behave yourselves and do not come to brawls during the question and answer session. Thank you so much.
So I guess I get to be the moderator. I don't know. I think what I'm inclined to do, rather than have a back and forth among us, the three of us, since we've run long, why don't we just go to the audience? And so raise your hand and you can direct a question at any one of us, including the moderator, the new moderator. Yeah.
Yeah, so thank you all three for your presentations, and I really appreciate your comments. I look forward to reading the book. But one of the things that just seemed to be the challenge, well, there are a couple of things. One being the challenge of definitions, right? How do you define what is discriminatory? How are you defining what it means to be harmed by religious liberty or not? There, you know, this idea of religious liberty, what does that really mean, and who's really being harmed? And in that vein, so you spoke to the issue of some of the issues related to the Civil Rights Act. I wonder how much of this conversation or the laws that are attached to this and trying to unpack this are correlated, for instance, with this idea of Christian nationalism. I know that was something that was also described. And to what extent can we learn more specifically about these issues as it related to the Jim Crow laws, right, and how those things were addressed? I agree. I think legislation is probably the only way to address this, but that is certainly not something that's going to be taken up. So I wonder how you think about this, the idea of public accommodation, the issue of commercialism, and really this overarching issue of Christian nationalism that's really in many ways helping to fuel these issues around how folks are defining what is harm.
Does anyone else want to say something about that? Maybe that may be mostly a question to me, but maybe the other panelists as well.
I guess I'd say the first thing that I'd say is the question of what is harm is already addressed by the statute. So we don't have, courts don't have to think in the abstract who is harmed who. They are presented with a statutory question of whether there has been a violation from an anti-discrimination law that normally applies to everybody. And so the question that's arisen is whether one ought to carve out an exception based on the religiosity of the claimant. And the practice of religious accommodation generally has been to give a religious accommodation if you can do that without defeating the underlying purposes of the statute. So then we have to explore the underlying purposes of the statute and see whether you can do that. The specific ideology of the religious claimant, whether the claimant is a religious nationalist or something else, I don't think has any bearing at all on the case. We accommodate religious objectors who we would like to keep away from political power, but it's still the case that they've got a religious accommodation, and people who have religions, religious people are particularly scary many times when their religions are different from ours.
Asma, do you want to say anything about any of those aspects?
Yeah, I mean, just on the point of Christian nationalism. So when I was talking about my book, I did say that the second book, and looking specifically at the conflict between white conservative evangelicals versus Muslims. But before I got to that, I had to kind of identify white conservative evangelicals as a relevant group here, not just one as a group of people who the data points as having sort of the highest levels of animosity against Muslims, but also in like the extent to which, if we're going to talk about bridge building, that is a possibility, right? And so in doing that, I had to also look at data that distinguished them from Christian nationalists. And there's a lot there that kind of puts sort of these believers across sort of a spectrum where you can begin to parse, what are these religious beliefs, in fact, mostly kind of just a voice or a cover for political positions, which would be the way Christian nationalist or Christian nationalism is defined. Religion sort of as used as an sort of offensive way to kind of exclude others, or is it something that is genuinely religious, something that tracks the rest of their sort of religious practice? And then in that context, you see that these claims are actually used in a defensive manner, kind of like, we're not here to exclude other people, we're not here to take away anyone else's rights, but we are trying to define and sort of carve out a space for ourselves in this country. And that's how you distinguish between those two different groups of people.
Yeah, I'd quickly say to add to that, some of these claims are brought by folks who are asserting them in an offensive way. I think if you look at least what some of the Catholic organizations are doing in, for example, the foster care case, they want to continue to provide a service that they've been providing for a long time, and that now has come under threat by the application of a non-discrimination law to it. The Catholic bishops, I think rightly, I'm not saying they get everything right or they hit the right tone every time, but they have rightly, I think, put their religious freedom arguments in terms of maintaining freedom to serve others, consistent with the beliefs that inspire our service to others. When that theme gets lost, and it does get lost pretty easily, it's bad. It's bad to lose that theme. But when that theme is centered and people focus around that, it's one of our good reasons for religious freedom. I'd just say about the race discrimination analogy, we treat racial discrimination uniquely in the law in a number of different ways. The bona fide occupational qualification provision in the anti-discrimination laws. You can hire somebody if it's you can discriminate if it's a bona fide occupational qualification. You can hire only women to act in roles playing females, or whatever. There are various kinds of rules. It doesn't apply to race. We have made the judgment because of history that racial discrimination has a sort of unique harms. I don't think we have to apply that same attitude towards every other form of discrimination. Other forms of discrimination are serious, but we don't have to say no exemptions ever, which is what we tended to say for race discrimination. Yeah.
So one of the challenges that I've noticed, like as millennial, is there are a number of millennials and Gen Z who kind of fall into a group called the Nuns that Christian Smith and Bishop Robert Barron, among others, have talked about. And like as a practicing Catholic, it's difficult to explain the concept of the importance of religious liberty to atheists and agnostics, especially in the millennial and Gen Z generation. What for Professor Berg and Professor Udine, do you have any tips on like ways of explaining that would be helpful for explaining it to agnostics and atheists?
Osma, you want?
Actually, Tom, you can go ahead.
Yeah. I I think that I mean, there are two ways to deal with the problem that religion is not the only thing that's important to people. One is to say, well, let's not protect religion particularly, because there are other things that aren't protected, and therefore we can't protect religion because we got to treat them the same. Can't have a special rule. That seems to me to be the wrong way to go. Right? Religion is important to people. It has historically been a source of suffering and conflict, and Lord knows it still is again today. That hasn't gone away. So what we ought to do is respond by protecting other rights as well. And that might include broader rights of conscience in some cases. That includes protecting marriage rights and family rights. It includes protecting other kinds of constitutional rights. We shouldn't respond to the expansion of other important interests to people by saying, okay, well, that means religion shouldn't be protected. I'm kind of cribbing from Andy Koppelman here, who says we don't protect sort of a very, very general set of things called things that are important to people. Right? We protect various kinds of things that are important to people. And the right thing to do would be protect marriage and family rights, et cetera, as well as religious rights. There's also, it's also true that religion is restricted in various ways under our Constitution. The Establishment Clause, the other side of the First Amendment, has restrictions on what the government can do in pushing religion on people. Here, I depart from the Supreme Court in one of the chapters of my book. I think that this Supreme Court has probably done most things right with respect to the Free Exercise Clause, but it's simultaneously allowing a lot more government symbols and government religious expression that is bound to be sort of a low-key Christian favoring Christianity. And I don't think that's a good development. If the court were more consistent on both sides in treating religion as a matter of special sensitivity, then that would be more even-handed.
I think I just want to add, there's a chapter in my Gay Rights and Liberty book where I tried to address exactly this question that you asked. And I think that for people who are not religious, you could understand the importance of religious liberty as an aspect of a more general right to be weird.
Okay.
To accommodate strangeness and idiosyncrasy and what is personal, and the nuns do seem to think about it that way. I mean, the problem always is, under what description you're going to involve. The idea of freedom of religion abstracts away from religious differences that are quite important to people. So I think the way to go is to get more abstract.
I mean, if I could add to, it's not exactly responsive to the question, but I would say in this context of religion and polarization, I think the question of what is religion is sort of being also implicated in some of the recent sort of controversies and debates around questions of abortion, and claims by minority religious women to, for a religious exemption from abortion bans. A lot of the scholarship about the attacks, for and against are looking, so the attacks against and support for are both looking at this question of sincerity, right? Like at what point are we going to sort of draw a line, or to what extent are we willing to probe whether or not these claims are actually religious? I think we've seen, these types of concerns about religion and sincerity in of course, many other ways, but I think specifically in the way that it intersects with religion, I can tell you that even in the Hobby Lobby context, there were some questions about, well, is this really a religious concern, or is it primarily political, or is it religious driven kind of mostly by political? And I think some of those questions are coming up in the abortion context as well. So I think that's sort of, when I'm talking about new phase of religious liberty, that's bringing up, even more interesting, complicated problems and puzzles for us to solve. I think that's one of them.
Thank you. Question over here. Okay. Yes. Father
So
Schlag.
I'm an
This is
Austrian,
Father Schlag, co-director of the Murphy Institute. So, yeah. Thank
I'm
you.
an Austrian constitutional lawyer and European constitutional lawyer, and it's very interesting for me to see how many topics are argued with religious liberty in this country, which would not fall under religious liberty in Europe, like abortion or contraception. All these things it would be just peripheral. But there's one issue, and some years back, Rowan Williams, who was then Archbishop of Canterbury, spoke about this concept of transformational accommodation for Sharia law in Europe. And his idea was that the courts in England should apply Sharia law to Muslims who wanted that, as long as they accommodated human dignity and equality of sexes. And there was a big outcry against him. And I remember reading a book by a Muslim female scholar called Ella Menea called Women and Sharia. And she pleaded with Western or European legislators not to be religious. Please stay just secular. We want secular law. Don't abandon us women to this law. So I wonder. This is some years back. Asma, you mentioned the case in Maryland. So I would be interested to know, if this is about gender self-identification and the preservation of same-sex changing rooms and toilets, and I don't know, this idea of Sharia law and application through civil courts. What do you think about that?
Sure.
You want to speak to that? I can say something quickly too.
Yeah. I mean, first, just a response to kind of what you were mentioning earlier about contraception and abortion issues not really being a religious liberty issue in Europe. I think it's also just the nature of the conversation around abortion and whether or not, I mean, in many of these European contexts, it is something that is left to the political process. And so I think that would be an argument that some people have put forward in favor of, for example, Dobbs, that when it is left to the legislative process, when there is kind of this space for negotiation, then you're less likely to see the type of political outcry, and also then the use, both, you can argue insincere or sincere, of religion as sort of a way to bring some of those legal claims, right? So, and so that's also something that we can spend a lot of time talking about. On the question of accommodation for Sharia law, like, I mean, in the United States, it also works similarly. It comes up in the context of religious arbitration and whether or not a religious community is able to arbitrate sort of a very defined, limited set of issues in accordance with their religious tradition, right? Which in many ways is an extension of freedom of contract more broadly. In some cases that applies in religious communities, but it applies in many contexts in a secular fashion as well. And the idea being that we're going to come to an agreed set of rules or principles that we want to be able to arbitrate, or again, these very sort of limited set of things according to. And again, criminal law is not something that's subject to it. And there are all kinds of checks and balances that people who are part of the arbitration process are there voluntarily, that there are sort of substantive and procedural sort of safeguards in place to make sure that there's no gender inequality or fundamental injustices. And then in order to enforce the actual decision, you have to take it to a civil court, where the court also then checks for all of these things and make sure that it sort of comports with American public policy before they actually enforce the decision. So that's how it works in the United States. I think, I can't really speak to in the European context. I know that there have been concerns raised in the United Kingdom, for example, the way Sharia arbitration works there. And so, again, I can't, but I would say that the version of this that I support is the version that we have in the United States, which doesn't legitimize the type of sort of nationwide movement then to sort of restrict Sharia arbitration. And finally, in Maryland, I should note that the claims themselves are not very specific to Islam. Like, they're not really, I mean, there have been concerns about modesty and like, girls who wear headscarves being in a bathroom where somebody who is biologically male or has male parts coming into that space and kind of violating sort of those religious rules around kind of religious modesty. There is part of that, but I think the lawsuit itself doesn't bring any of that. And Muslims, even though they're the face of this publicly, are joined in the lawsuit by Catholic and other Christian families. And in the Maryland context specifically, the request is simply for the ability to opt out from the LGBTQ curriculum. It's not anything related to the bathrooms. It's not even about banning books or stopping a curriculum. It's simply asking for the ability to opt out of the curriculum. And even that is something that the county is forbidding.
Let's make this the last question. We'll come up to
Kind of this
1:45.
question, just thinking about like the general subjugation of women within the context of patriarchal religions, and just thinking about the tension there generally, but then also, we seem to me like you all approached it from the premise of like we should be protecting religions equally, seeing religious practice as a good. And I'm wondering if there's any thought around we should be marginalizing religions equally to the extent that they subjugate or discriminate on class distinctions or protected status distinctions, right? So like your religion should be marginalized to the extent that practicing it faithfully involves marginalizing LGBTQ folks or subjugating women or et cetera. So like is there kind of a secular counterpoint to the equal protection and equal marginalization?
Well, every major religion is contested along these axes. So, saying that, saying that religions are patriarchal is like saying that all human beings are male. It's partly true, but it's way more broad. What the patriarchal religions are pushing back on is precisely the anti-discrimination laws at issue. And as I said, the question is, can we accommodate you with your strange beliefs without defeating the underlying purposes of the religion? It is my view that anyone who thinks that there is a moral difference between same-sex and opposite-sex couples is mistaken. My view is that all those people are mistaken. In a better world, those people would change their minds. On the other hand, this is a free society, and I don't think that it's appropriate for government to try to entirely eradicate views with which it disagrees. So those people and their religious organizations in a free society should be able to have their associations, to live by those rules. What's important is that there be an exit option and they not be able to impose those views on non-adherents.
I think I'd agree with those points, and only say, I guess, that the history of suppressing religious freedom or restricting religious freedom that gave rise to the kind of cycle of back and forth, and that's causing similar harms today, included going after faiths because of their practices within the faith and the negative effects that those might have on people within the faith, right? So then, right, what's the connection between that and the effect on the broader society? If the government's business includes preventing harms within the religious community, then that's a very broad mandate, a very broad agenda, and that authorizes government to be involved and to create the sort of cycle that we've got. The move at the time of the founding was protect religious freedom unless it has some effect on public peace, public safety. Those are hard lines to draw, but if we don't draw some sort of line like that, we're back into the harms or the problems that religious freedom was meant to address. I think would be my answer. Okay, everybody, thank you very much for coming. Appreciate very much. There are books outside if you're interested, and thank you for staying on for a few minutes.